Today, the president's team answered the impeachment allegations and accusations that basically suggested that in the impeachment, that merely raising questions about the election was somehow illicit incitement, that it was not brought in good faith, that it was brought in bad faith, and that somehow it could constitute illicit incitement. So let me address that election contest component and be in defense of the president's right to bring the election contest and, in fact, how his conduct was conforming to the Constitution, not contrary to it. The issues of the election contest have been broadly misunderstood. There have been various statements made about the election contest, often conflating and confusing people that were not the president and their particular issues with the election with the president's challenge and contest. The president's election contest concerned three issues. First, did only lawfully qualified voters cast ballots for the presidential election? Second, was the method by which those ballots were cast lawfully cast? Third, was the counting of the ballots done in a lawfully correct manner, so that only constitutionally qualified people vote? Was the manner in which their vote was cast, was that a constitutionally cast ballot? And was the manner in which the ballot was counted a constitutionally counted method of counting? There were issues of all three in 6 states where the margin of victory was very light and was less than the number of questioned or contested ballots. Indeed, the grounds of an election contest is that you need 2 components, not just a unconstitutional manner and method in which the election is conducted, either because unlawfully qualified voters are voting, they're voting in an unlawfully qualified manner, or the vote is cast in an unlawfully or counted in an unlawfully counted manner. It's also that there's enough votes in those 3 categories, individually or in aggregation, that it exceeds the margin of victory between the candidates. That's why an election contest has 2 constituent components. And some objections raised to the president was that why wasn't he contesting states that where the margin was much larger but that had the same questions? Very simple, because in order to have grounds to challenge an election, first, you can't be the winner of that particular state, then you don't have grounds to challenge it. And secondly, you must have more votes in question than constituted the margin of victory. The 6 states in question, Pennsylvania, Michigan, Wisconsin, Georgia, Arizona, and Nevada, had very small margin of victories, in some cases as small as within the tenths of a percentage point, according to the certified vote by the election officials from those respective states. So the question was, first, were there any votes cast by people who were not lawfully qualified to vote? As the research from Matt Brainerd, the research from Richard Barris, the People's Pundit, the research from the Trump's legal team documented, there was substantial evidence and red flags that more people voted who were not qualified to vote than the margin of victory in each of those 6 states. This included people who appeared to be dead. This included people who appeared to not even be citizens. This included people who appeared to have voted in duplicate, either in other states or twice within the same state. This included people who were not registered to vote at an actual lawful domicile, but appeared to be claiming they lived inside a mailbox. All of those categories of questioned voters, as well as underage voters, apparently voting in some states, such as Georgia, who are not constitutionally qualified to vote under the laws passed by the state legislature. And that's important. In the presidential context, the key rules are only those rules passed by the state legislature, because the electors clause of the U.S. Constitution says the only body that can set the rules for a presidential election is the legislative branch of the individual states, not the judicial branch, not the executive branch, not anyone else. And so the question was, according to the constitutionally conforming rules established by the legislatures of these states, did anybody vote who was not qualified to vote? And they found examples and prima facie evidence that not only did that occur, but that it occurred in such a volume that it exceeded the margin of victory in each of those states. And they only needed a few of those states to establish grounds that there was no proper majority of electoral votes that could be certified. And the Constitution under the 12th Amendment and prior to the 12th Amendment said that if there is an insufficient majority of electors present that can be adequately certified from an accurate count, then Congress, by state delegation in the House of Representatives, it decides the presidential election. The same House of Representatives that was just chosen in the same election. And so they get to determine and decide the election. And the question was, if to go to the House, was there inadequate certification done in the prior process because of those three components: unlawfully qualified voters voting, unlawfully cast methods of ballots being cast, and unlawfully counted methods of voting according to the constitutional rules as established solely and wholly by the state legislature. So there's plenty of evidence that people that were not lawfully qualified to vote voted in each of the states. Second, there was also evidence that they cast their ballot in a manner that was not lawfully qualified. In particular, we had a record-setting flood of mail-in absentee ballots. For decades, there has been great concern about the risk that mail-in balloting presents to an accurate, honest vote. This included the New York Times, which in August of 2012 warned that an increase in absentee mail-in balloting would almost guarantee an increase of fraudulent ballots being cast. And it doesn't even require fraudulent ballots, just ballots being cast in a manner that are not consistent to the lawful requirements of the local state legislature. So in particular, there used to be rules that established that if you were going to vote away from the supervised secret control of the ballot, a location of the ballot box, given we adopted the Australian secret ballot more than a century ago, because voting from home doesn't have a secret ballot component. Voting from home, the ballot could be stolen. Voting from home, the ballot could be fraudulently taken. Voting from home, the ballot could be forged. Voting from home, the ballot could be bought. Voting from home, the ballot could be bribed. Voting from home, the ballot could be extorted. Voting from home, the ballot could be blackmailed. These are all risks that leading election experts talked about, including in that August 2012 New York Times article. So the only check on this whole process, when they removed the requirement that it be independently notarized to make sure the person filling out the ballot is the person doing so and doing so in secret, and no evidence of bribery or blackmail or extortion taking place, that was mostly removed from many of these states. No such requirement was imposed. In the few states that had it, they removed it. Not only that, you could cast the ballot by dropping it off in a drop box, so the chain of custody of the ballot was interrupted, rather than having to go straight from the person to the mailman to the voting booth. Instead, you had a drop box intermediary where ballots could be compromised. And most importantly, the only check left was a signature match check to match the signature on the absentee ballot envelope outside of the ballot that could be checked against the confidential signature of the voter in the voter file. And if they use the same strict signature match methods and standards they used for nominating petitions of third parties and independent candidates, including in 2020, at least 20% of such signatures would be routinely and repeatedly rejected. In the primaries in New York and New Jersey, that's what took place in the summer. You saw a rejection rate as high as 20, 25, 30%. And you had a record number of people voting by this method who had never voted for it by it in the past, and that had historically been strong evidence that, in fact, they would make comparable errors in this election. Yet, when it came time to do signature match checks, we had one of the lowest rejection rates in the history of the country. So we have a record level of participation of people voting by mail, but a record low rejection rate when everybody thought the reverse would be true by historical metrics. And so the question was, did people cast the ballot in a manner that was not constitutionally qualified because it violated the signature match standard requirements passed by the local state legislatures in each of these states? The third question was whether it was counted in a constitutionally qualified manner. Did it conform to what the state required and how the canvassing and the count took place? The canvassing is when they bring it in, and that's when they separate ballots from their envelopes, and this allows for party observers to independently confirm that the rules are being enforced in the canvassing process and the counting process. They allow also for party observers to be present, and that means to meaningfully observe the process, to confirm no irregularities in the counting of the ballots. So the question was, did that occur? Well, there was evidence again in many of these states, in key counties, including Clark County, Nevada, including Wayne County, Michigan, including Milwaukee County, Wisconsin, including Philadelphia and Allegheny counties in Pennsylvania, including Fulton and other counties in Georgia, where you have democratically controlled election apparatuses excluding party observers from both the canvassing process and the count process to make sure it was done in a constitutionally conforming way as required by the rules passed by the local state legislature. And in many contexts, in many cases, in many states that were under contest, there were more ballots that were counted in an irregular, non-constitutionally conforming manner than was the margin of victory, some cases by a large multiple. So the president had legitimate legal grounds to challenge whether only constitutionally qualified voters voted, whether only the way in which the votes were cast, whether they were constitutionally qualified cast ballots, and whether the votes were canvassed and counted in a constitutionally conforming manner. There were major problems in all three. From an evidentiary perspective, there are major problems from all three in terms of their legal consequence, because the number of ballots in each of those three categories exceeded the margin of victory in each of the 6 contested states. So the president went to the constitutionally authorized bodies to adjudicate this, including to the state legislatures, including to the state executive branch, including to state courts, including to federal courts, and ultimately to Congress. Those are the bodies given constitutional authority to adjudicate and resolve these controversies. Unfortunately, and contrary to conventional wisdom, none of them ever allowed a meaningful trial to occur on the evidence. None of them allowed a meaningful trial on the legal merits. The biggest case, the U.S. Supreme Court case, where 18 attorney generals representing about half the country joined, including hundreds of congressmen and state representatives and millions of citizens through their public advocacy groups, in the biggest case ever brought before the U.S. Supreme Court concerning a presidential election, the U.S. Supreme Court failed to conduct any trial, failed to allow any discovery, failed to permit any legal argument, and failed to rule on any of the legal substance. Indeed, they used a Pontius Pilate pretext to wash their hands of this controversy and dispute, and other courts followed suit. The only election contest personally brought by the president in Georgia, they wouldn't even allow a hearing to be scheduled until after the certification on January the 6th, effectively mooting the entire process, even though Georgia state law required that they hold a hearing sooner. So this is the way in which the process worked. The courts absconded from their opportunity to adjudicate the matter, and then the state legislatures claimed they couldn't meet, so they absconded from their duty to take up the matter. And last but not least, Congress itself failed to hold a meaningful hearing authorizing meaningful discovery with a meaningful trial on what took place. Did people who are not constitutionally qualified vote? Did people who were cast ballots in an unconstitutionally qualified manner? Was the counting and the canvassing of the ballots done in a manner that did not constitutionally conform to the state legislature's requirements? There was evidence that all three were present. There was evidence that each of the three, and definitely all three in aggregate, exceeded the margin of victory in each state. And unfortunately, that evidence never saw a meaningful trial. People are talking about other cases involving other people who claim to be allied to the president. The president's cases never got a jury trial, never got a bench trial, never had a substantive hearing on the legal merits. Just didn't happen in a meaningful, consequential way in almost every single case. There were a few cases that dealt with limited components of these issues, but not the whole scale and scope of these issues. Nobody dealt with all three. In fact, to this very day, no county in any state has allowed party observers to match the signatures at any level. In the one state that allowed even a small sampling to be done, the Democratic Party's own expert in Arizona determined that more than 10% of the signatures did not conclusively match. The court decided to abscond from the issue by changing the legal standard to something that couldn't be met. But again, the only time we actually had an independent party observer partake, the Democrats' own expert said more than 10% of the signatures don't conclusively match. None of the other states have allowed any party observer to take place and partake in the signature match process ever in this election, to my knowledge. Indeed, they didn't allow party observers in the canvassing of the ballots in most of the counties in most of these states in a meaningful manner. They didn't allow party observers to participate in a meaningful manner in the count of the ballots, with often highly irregular and unusual activities taking place in major democratically controlled counties where they were excluded or by hook or by crook from being able to watch the counting of the ballots. Many were not even allowed to meaningfully observe the recount of the ballots, such as took place in Georgia and in parts of Wisconsin. So we did not have the procedures and protocols put in place by the United States Election Assistance Commission, which recommended these rules that were then adopted by the state legislatures to make sure you have only qualified people casting ballots in a qualified manner, where the canvassing and counting of those ballots is also done in a correct, qualified, constitutionally conforming manner. They failed at each of the three critical stages of an honest vote for a constitutional election. So the president was fully entitled to raise his questions to the authorized bodies. They simply failed to meaningfully adjudicate it in a way that could ever be evidentiary substantiated. And so he was left only with going to Congress, who had asserted that authority to contest electors since 1809. The vice president had been involved in contesting and resolving potential electoral contests since John Adams in 1796. Thomas Jefferson resolved one in 1800. Richard Nixon did it in 1960. So the idea that the vice president had authority to resolve contested elector issues has a long history going back to our founding fathers. The idea that Congress has a right, a role, a responsibility in determining whether only qualified voters voted, only qualified methods of casting ballots were done, and only constitutionally qualified counting and canvassing of the ballots occurred for this presidential election has a history that's more than 2 centuries old, going all the way back to the 1808 election where members of Congress objected. So the president's actions did not conflict, or nor were they contrary to the Constitution. They conformed to and sought to enforce the Constitution. So not only can it not be illicit incitement under the First Amendment to the United States Constitution, which requires explicit threat of imminent lawless action, what the president was doing was seeking lawful remedy for issues that were properly identified as legitimate issues, which never got a full and fair hearing in either court or Congress. It was the courts in Congress who failed their test, not the President of the United States. And that is additional reasons why the president should not be removed from office, not be disbarred from future office, as this current impeachment attempts to unconstitutionally attain. But it's why his election contest was in good faith and was constitutionally conscientious, not constitutionally condemning in his course of conduct. Thanks for joining.